Hello, and welcome to another edition of Coffee Talk with attorney Brian D. Lerner. We have several other videos on estate planning and all of the different varieties and subjects. In this particular episode, I'd like to talk a bit about testamentary capacity. What does that mean? Well, a lot of times when people make wills and they put their signature at the bottom, basically they're saying they're going to give whatever to whomever. Okay. And the reality is there is a great deal of uh, people and family members who are greedy and who will try to do whatever they can do before somebody passes away to get their share, which may not be what the person making the will wants. And so it has to be shown that somebody who is making a will, who is signing the bottom line and saying they're going to give, their house to Joe and their all their jewelry to Mary and all that, it was done in a manner that they had the proper understanding and mental capacity to know what they were doing. There's actually been lots of case law and lots of statutory law on what is needed in order to show that a testator, that's the person who makes the will, has the mental capacity. Now, first, it is presumed that somebody making a will does have testamentary capacity. So essentially, the burden rebutting this presumption needs to be shown by a preponderance of evidence. Okay. Now, this is not a terribly high burden, but if, for example, you know that someone has, dementia and can't remember their, children's names, and all of a sudden they have a very comprehensive will made that they devise everything to, their sister-in-law. Um, you know that there is most definitely an issue with mental capacity. Now, the the determination that a person lacks capacity to do a certain act um, has to be shown in several different ways, but basically showing that they don't have the alertness and attention, they can't do the information processing, their thought processes are basically not normal, and that they just don't understand what's going on. Now, just so you know, um, the capacity required to execute under many tests is actually less than the capacity required to execute a contract. So, while the burden is not terribly high, it still needs to be shown, and there still needs to be testamentary capacity. So, what is it that you have to look at in order to determine if a person has testamentary capacity? Well, here's the bottom line. A person does not have the testamentary capacity to enter or do a will if they do not understand the nature of the testamentary act, which means they don't understand what the will is. Okay, if they can't understand and recollect the nature and the situation of their property. So, you can't bequeath all your jewelry to Joe if you don't know what the jewelry is, okay? Or you can't bequeath the house to your Aunt Mary if you don't realize that you own the house, okay? Um, you have to remember and understand your relations to your living descendants, spouse, parents, and those whose interests are affected by the will. So, if again, for example, if you bequeath everything to and you don't remember who your children are, then that definitely is a lack of testamentary capacity. Okay, um, if you suffer from a mental disorder such as delusions or hallucinations, um, and you're giving your property to someone as a result of those delusions or hallucinations, then you would be able to show that you don't lack the capacity. So, all in all, you have to make sure that those three items that I just discussed are properly met in order to show that the living will is proper and that you have the capacity. Now, understand capacity is different than duress. So, for example, if Aunt Mary puts a gun to your head and says, "Bequeath me the house or else," um, that's duress, and we'll make another. I'll make another video on that at some later point. But at least for testamentary capacity, this is the basis for it and the general tests so that you know what it is, how to spot it, and where to go from there. Okay, more on the coming videos.